People versus Willis.
May it please the court, Sylvia Lara Altruder of the Legal Aid Society on behalf of McKenzie Willis. I would like to request 2 minutes for rebuttal.
Yes.
The misdemeanor complaint charging Mr. Willis is facially insufficient and must be dismissed.
Does it matter that the defendant waived being prosecuted by an information here?
It matters in terms of the analysis, but even under the less stringent standard of a misdemeanor complaint, the complaint charging Mr. Willis is still facially insufficient because one of the elements, the element that makes this a crime and not a non-criminal traffic infraction, is not sufficient.
And what is the purpose of a complaint versus an information?
The complaint initiates the proceeding, but somebody can only be convicted on a misdemeanor complaint with their own consent.
But we still use the standard for a complaint where you've waived the information, right?
That's correct.
And that's, I think, facts of an evidentiary character supporting or tending to support the charges.
Yes. And here there are not sufficient evidentiary facts pled to establish that Mr. Willis knew or should have known his license was suspended the day he was arrested in 2018. The first problem with the misdemeanor complaint is that there is no allegation that Mr. Willis ever received the traffic summons that's alleged to be the basis of his knowledge that his license was suspended. The second problem is there's no allegation.
Why isn't there enough to infer that he did receive them? And of course, if he wants to, or if he went to trial and wants to argue otherwise, that would be a defense, perhaps.
There's, in the VTL is very complicated. There are lots of ways that people can get sanctioned under the VTL. There are now thousands of traffic cameras in New York City alone. There are congestion pricing cameras. There are red light cameras. There are speed cameras. There are, you get tickets.
But my read of the rules, tell me if you disagree, is that the summons has to be delivered by personal service or put on the car windshield. Is that right?
It's not totally clear, I think. I think there's some confusion about how exactly, for what kinds of traffic infractions.
For the types of infractions at issue here, you think it's not clear?
I think it's not clear.
And what would the other means of delivery be if not personal service or affixing to the windshield?
By mail would be the other option. For example, people get certain kinds of mailing when you run through a red light, when you're speeding in a
Do
school
you
zone.
usually get a seatbelt summons by mail?
I'm
Isn't
not-
that one that's normally delivered to the person in person?
That's not alleged in the complaint, that the officer who swore out this misdemeanor complaint knew that Mr. Willis knew he had a suspended license because he had gotten a summons for driving without a seatbelt.
But you do concede that there are some class of summonses that are handed directly to the violator.
Yes.
Okay.
And I would guess that wearing a seatbelt is one of them.
That's not totally clear to me. There are cameras everywhere. You can see on a camera whether somebody is wearing a seatbelt or not.
And you could
Are
be
you-
summons ticketed for that
you-
by a camera violation? Is that what's going on in New York right now?
I don't know, and I think if that were the basis for the officer's belief that Mr. Willis was driving on a suspended license, that needed to
But
be
even
alleged in the complaint.
There are instances, cars are pulled over if an officer observes someone without a seatbelt. That's a reason to pull them over.
Yes.
When you pull them over, they get the ticket.
Yes, and if that were alleged in the complaint, that would be
So every
different.
specific thing has to be alleged.
Yes. This was a very serious case for Mr. Willis. These misdemeanor cases are very serious. The only thing
But
that...
what about the argument that if he wanted the particularity that he's complaining of, he should have proceeded to trial and been prosecuted under an information?
The only thing that is the
Because they
check...
serve two different purposes.
The only thing that is the check on the prosecutor's ability to bring these cases is the facial sufficiency of the instrument itself.
Well,
Even
the-
for a
the in-
misdemeanor...
The instrument attaches his driving record, right?
Yes.
And it has an address on it and his name on it. And so to sort of Judge Rivera's question, why can't we infer that he got at least one of those?
There's no allegation, for example, that a notice of suspension was mailed to that address.
So you need an affidavit from the person who did the mailing testifying to the act of mailing it? Is that the suggestion?
That would be one way to do these cases. Another way that many prosecutors do in these kinds of cases is that they allege that based on their training and experience, they know that notices of suspension are mailed to a person's last known address.
Given that there are a multiplicity possibly of ways that these summonses get delivered, why not go with the people's argument that this can all be handled as a defense? You can say, I never got the summons, and we can work out what the truth of the matter is as part of the merits determination.
That would have been one option, but for this complaint to have been jurisdictionally sufficient, for the court to have accepted Mr. Willis's guilty plea, the instrument needed to allege every element of every offense, and knowledge is not properly alleged here.
So if the complaint had said, I know that the driving record that is attached here is the, items show up on this driving record once they are mailed to the address shown there. If the officer had said that in the complaint or something like that, is that sufficient?
That would be a different situation. I think that would be better. If they had
Well,
alleged that.
I didn't ask about better. Would that be sufficient?
If they had alleged that, based on their analysis of the abstract, that these particular traffic summonses would have been handed.
No, I was asking something different, not these particular ones, that it's a general practice that these are mailed and they don't appear on the abstract until they're mailed.
Even so, the other problems with the instrument.
Would that, oh, sorry, would
I'm
that be?
going to say no. I think that that would not be sufficient.
So what more would you want then?
So the easiest way, I think, to do this for the prosecutor's offices would be to allege the notice of suspension itself, that it was mailed in the ordinary course, but.
Well, sorry, that's back to Judge Canataro's question, that you need to have the person who mailed it fill out an affidavit to that effect.
I think for an information, that is what you would need, but for the purpose of a misdemeanor complaint that can be based on
What
hearsay.
about, how does the presumption of regularity come into play with respect to him getting it?
The presumption of regularity would have applied here if the prosecution had alleged that the summons was handed to, would have been handed to him in the ordinary course. Then I think the defense is that, well, in this particular case, it didn't actually happen. That wouldn't apply here. The presumption of regularity would have attached. But here, there is not that allegation in the complaint, such that the presumption could attach. But to go back to one of the earlier questions, the warning, the officer does not articulate any basis for his knowledge that the printed warning on the back of a summons was actually there, which I think.
So does an
Wait,
officer have to allege with respect to their experience and knowledge base from being a police officer, they have to allege all of that in the complaint?
For things that are not obvious, I think this court had held in other cases that an officer doesn't need to allege that they know something is a public place, or that they know something is in public view, or they know something is
So what's the
for
problem with the averment? Is that a word? What's the problem with averring, I know that this information is on every summons?
that they don't, that the officer here doesn't articulate a basis for why he knows
I'm a
that.
police officer. I've served thousands of summonses. I know that that information is on every summons. That's not a sufficient.
That would have been sufficient if the officer had said, I personally have served thousands of these summons for these traffic infractions. That would have been sufficient. But we don't know anything about this officer. And if they had alleged based on their
We
training.
know
and
he's an
experience-
officer.
Being an officer isn't sufficient to establish that something is a
There
gravity
was a
knife. They
way-
can't just say that. Sorry.
There was a way to get more information without going to trial. I mean, your client waived prosecution by information, which is a much higher standard. We've said it's much more stringent, and pled to a complaint, which he otherwise could not have done without waiving. And now it seems that you want a level of information that might be required by an information proceeding, if they had filed an information, but isn't for a complaint. And that was a decision that was made at the police stage. It was a waiver.
Mr. Willis did waive the right to be prosecuted based on non-hearsay information and to be subject to have an information subject to this higher standard. But even under the lesser standard, this complaint is still not facially sufficient. In the same way that an officer has to.
But do you agree if he hadn't waived, he would have gotten the specificity he is now complaining of?
I don't know. I can't speak to what would have happened if Mr. Willis.
He would have gone through the process, and he is entitled to the heightened pleading requirements if, in fact, he were going to trial and to be prosecuted on the information.
Yes, that's correct. He would have gone through the process. The third problem with the complaint is that even crediting that Mr. Willis received the summons and even crediting the idea that all summonses have this particular printed warning, the warning as written did not provide him notice that his license was suspended the day that he was driving. All of these suspensions are relatively close in time, and the ticket isn't alleged to say your license will be suspended on some particular date.
Some of the first one of these was several months before he was pulled over.
I believe it was, the first violation on his record was for disobeying a traffic device, and that was in June, and he was pulled over in October, so 4 months. But there are lots of things that go wrong with the DMV, there are lots of things that could have gone wrong here, and Mr. Willis was not put on notice that his license was suspended when he was driving at the time.
Yeah, but that sort of, the speculation of what could have gone wrong, and that is not necessarily a basis to say that it's jurisdictionally defective.
They're still needed under the statute for there to be some reason to believe that Mr. Willis knew or should have known his license was suspended, and there are not sufficient reasons set out in this complaint. Finally, I'll briefly address what some of the questions have alluded to, which would be a standard that this court could apply in all of these cases. There are lots of ways that these complaints could be alleged. They could be alleged, for example, that based on an officer's training and experience, these notices of suspension are mailed to a person's last known address in the regular course of business. That would be sufficient for a misdemeanor complaint. They could attach the affidavit that the
But
court
it
was.
sounded from something you said earlier, you would want the officer to say how the officer knew they were mailed.
That could be based on their training and experience, or it could be they worked at the DMV in their own personal experience
What
getting
would the
these.
training and experience of an officer who's on the street stopping cars be as to the mailing of the summonses?
I think that would not be a basis for.
Okay, so that rule doesn't work.
I think, though, officers, I assume, take classes on how other agencies function in terms of enforcement. The officer here alleged that he knows.
Well, if you assume that, why can't we assume that happened here?
I take your point, but I still think that the officer needed to allege, if that were the case, why they knew what was written on the ticket, why they knew that somebody's license is suspended 4 weeks after they failed to answer a ticket.
Well, he says all such summonses have printed on them, if you do not answer this ticket by mail within 15 days, your license will be suspended. So you want more than that, but how would his training expose him to what DMV does internally?
If his training did not expose him to how the DMV actually works, then this entire complaint is completely insufficient.
So let's assume that he has an hour-long class and somebody from DMV comes and says, this is what we do. Would that be sufficient?
Yes, to establish the,
And would he need to allege that with specificity, in
He would
your
have to
view,
allege
in
that
a
as-
complaint?
As the basis of his knowledge?
I don't think he would have to say specifically, I took this 1 hour class on this specific day, but I think he would have to allege some basis based on their
So
police officer's
saying I
training.
know is not enough. He has to say I know for the following reason why.
For this proposition, yes. Thank you.
Thank you.
Your Honors, and may it please the Court, Anna Nachik for the people. When judging the accusatory instrument under the deferential standard applicable to a misdemeanor complaint, the accusatory instrument here was facially sufficient. It established reasonable
Don't we need
cause.
to know the basis for the officer's assertion?
No, Your Honor, we don't. The cases where this court has found that there is some specialized knowledge of the officer that must be pled in a complaint have required a conclusion that the officer made based on his experience and specialized knowledge of an officer. Dumas was the marijuana case where the officer determined that something was marijuana. Drayden was a gravity knife case. those required specialized knowledge to understand that something was marijuana or was a gravity knife. There was no specialized knowledge needed here for the officer to know what the summons said. A simple reading of a summons would be enough, and we can infer that the officer here read the summons because he said, I know that all such summonses say, if you do not answer this ticket by mail within 15 days, your license will be suspended. So there was no additional pleadings that was based on his experience and
Is that because of the detail of that particular phrase that you just used? It seems to have particular information that one would infer. You didn't just make that up. You must have seen that somewhere.
Yes, Your Honor, and we can infer that because this standard that is used is that of a misdemeanor complaint, which is much less stringent than that of an information, and we can make reasonable inferences. From his saying, I know that all such summonses say X, we can infer that he has read a summons and knows what is printed on them. Further, the complaint alleged that defendant's license was suspended for failure to answer a summons. We can infer that defendant was issued a summons, and a reasonable inference can be made that he was personally served with that summons. Common sense and everyday experience show us that when someone is given a ticket or a summons, that is directly handed to them, and that is especially the case when that summons is given for a traffic violation. Here, we know that defendant's summonses were given for traffic violations because we have his DMV abstract, which shows that in June of 2018, defendant disobeyed traffic laws, failed to wear a seatbelt, and performed an improper right turn, and that he was given a summons on each of those occasions. Those are the type of traffic infractions that defendant would have been pulled over and directly handed the summons. So we can infer that he actually received the summons. And once defendant received the summons,
But counsel says you can't just assume he personally received them in those instances.
we're not just assuming, we're not assuming that, Your Honor. It's the reasonable inference that can be drawn from the fact that these were issued from traffic violations.
You are looking at the totality of the circumstances, and inferences can be made, and that's how you come to that conclusion. Does it matter that whether it's an information or a complaint and that the defendant waived prosecution by an information?
It does matter, Your Honor, because prosecution by complaint is a much less stringent standard than that of prosecution by information. Defendant could have declined to waive prosecution by complaint and had the people prosecute him by misdemeanor information, but that's not what happened here. And so the people did not need to provide non-hearsay allegations of every element of the offense, just a more holistic approach of whether there was reasonable cause to believe that the defendant committed the charged crime, and there was. As soon as defendant would have received that summons when it was personally given to him, he had reason to know that his license would be suspended if he did not answer the summons. The summons, as the officer alleged, had printed on it, if you do not answer the summons within 15 days, your license will be suspended. So
What about the order of protection cases that your adversary relies on? I'm thinking of People v. McCohen, which we said basically an order of protection was issued and the defendant was aware of it, but that doesn't necessarily mean that he was aware of the contents of the order of protection. Isn't that analogous to this situation?
No, Your Honor, we do not believe so because defendant was specifically aware of the fact that if he did not answer that summons, his license would be suspended. That he may not have ever actually received that notice of suspension is not relevant to that analysis because as soon as he did not respond, he had reason to know his license was suspended. And we do believe that is different than the order of protection cases. Further, the fact that this possibly could have been mailed or affixed to defendant's car, defendant could still have reason to know his license was suspended, even if it was the summons was issued for those different in those different manners. Because if it was mailed to him, whether or not he actually received that mail is a defense to be raised at trial. And many of the claims that defendant makes now are defenses to be raised at trial rather than challenges to the sufficiency of the accusatory instrument. Turning quickly to remedy, even if this court were to determine that the accusatory instrument is not sufficient, it should decline to dismiss the accusatory instrument and should instead remand defendant's case to criminal court. Where the people do not agree that dismissal is appropriate and there is a penological purpose in sending the case back to criminal court, this court should decline to dismiss an accusatory instrument. Here, the people do not agree that dismissal is appropriate and there is a penological purpose in sending the case back because the future degree of an aggravated unlicensed operation of a motor vehicle charge could be affected by a conviction here. I'm happy to address any additional questions, but if there are no further questions, we ask that you affirm. Thank you.
I'll address 2 points by the prosecution. First is that I think the order of protection cases apply here because just because a summons was issued for these traffic infractions does not necessarily mean that Mr. Willis received them. And the other point I'll address is the peniological purpose for remanding this case. Mr. Willis was arrested in 2018. It would only have a peniological purpose in heightening his subsequent aggravated unlicensed drivings if he were to have been arrested in the 18 months following. It's now 7 years later. There's no purpose in remanding this case. The fines in this case, there was a $200 fine and an $88 surcharge.
What does the 18 months run from? The date of conviction or the date of infraction?
The date of the offense. So that has long since passed. But back to the peniological purpose, this was now 7 years ago. This was a $200 fine and an $88 surcharge that Mr. Willis was unable to pay, and civil judgment was entered. There would be no purpose in remanding this case.
But isn't there a purpose of having people be licensed drivers upon our roads as they're supposed to? Isn't that a public purpose?
That would be a public purpose, but the point has been made. Mr. Willis spent months going to court for these cases. He's had a misdemeanor conviction and a criminal record because of this case for now 7 years. There is no purpose in having him return to court and face criminal prosecution again on this case.
Thank you.
Thank you.
Next case is People versus Martinez-Fernandez.
May it please the court, Sylvia Lara Altruder of the Legal Aid Society, on behalf of Edward Martinez-Fernandez, I would like to request 3 minutes for rebuttal.
Yep.
Nice to see you again.
It's been a long time. I'm going to address the difference in Mr. Martinez-Fernandez's case with respect to the 511 charge. The only difference in the factual allegations underlying his complaint versus Mr. Willis' complaint is the allegation that he was unable to produce a valid license. As was talked about yesterday before this panel.
And what impact does that have on this case versus the other one?
None. The complaint charging Mr. Martinez-Fernandez is still facially insufficient. Not being able to produce a valid license does not mean, as was argued yesterday, that he knew or should have known his license was suspended. Not having a physical copy of your license has very little to do with knowing your suspension. When your license is suspended, you don't turn it in. And the fact that he, at some point, from his trip, from the traffic accident that he was involved in to when he was arrested.
Did you say when your license is suspended, you don't turn it in?
That's correct.
Aren't there instances where you have to surrender your license?
I believe in certain cases there are, but that's not alleged here. And not in all cases. But yes, not in all cases. But there's also no connection. Mr. Martinez-Fernandez was arrested at the hospital. There's no reason that not being able to produce a valid license at some point between the accident and when he was arrested at the hospital means that he knew that his license was suspended.
I mean, maybe solitarily that's true, but I think in conjunction with everything else that's in the complaint, why isn't that a reasonable inference to say that, and by the way, he didn't produce a license, which the reasonable inference is he didn't have one or it was suspended. And then everything else that you just mentioned becomes a defense.
It would be, I think it would be presumptive evidence that his license, that he didn't have a valid license, which would support the traffic infraction, the VTL 509. It does not support the aggravated unlicensed driving of the VTL 511. And for all the reasons I talked about, the form allegations, these boilerplate allegations about the summons and the language that's allegedly on the summons and that your license is suspended 4 weeks later by computer, are insufficient to show that he knew or he should have known his license was suspended. I'll then turn to the reckless driving charge. So Mr. Martinez-Fernandez's case, the charge of reckless driving does not help this complaint survive. There are no non-conclusory allegations in the complaint that Mr. Martinez-Fernandez was doing anything unsafe, that he violated the rules of the road, that he was speeding, that he had been drinking, or was in any way at fault in the traffic accident that followed.
Well, he crossed a double yellow line and the motorcycle hit him.
Yes. And crossing a double yellow line is not per se illegal.
No, but you do have to give way to traffic that has the right of way.
And there's
on the
no
other side of the double yellow line, right?
I'm sorry, could you repeat the
Yeah,
question?
sure. I mean, you cross the double yellow line, the other traffic is coming the other way from the way you were going, right? That's necessarily true.
Yes.
And you have, if you're crossing, you have to cross with extreme care and make sure there's nothing coming at you.
Yes.
And a motorcycle crashed into him.
Yes. But that there's no evidence in the complaint that Mr. Martinez-Fernandez was at fault for that accident. What he says, and what's alleged in the complaint, is that the motorcycle was speeding when it hit him. The officer that swears at the complaint, she alleged that he caused the motorcycle to hit him. Causation is a legal conclusion, and there's no basis for the idea that Mr. Martinez-Fernandez was at fault for the accident. There's no allegation, for example, that he wasn't acting with care. What he says is that he was trying to park, which for many people, they take tremendous care when they're trying to park on the side of the street. And so for that reason, the entire instrument is facially insufficient. And so we would also ask that the remaining VTO 509 charge, the traffic infraction that remains, be dismissed. There is no peniological purpose in proceeding on that remaining charge, and the prosecution does not contest that. If there are no other questions, I will see my time.
Thank you.